NACDL is the association of the nation's criminal defense bar.
No time for losers. You guys are the champions. So I welcome all my champions to Credits Without Contact. Today is a little tear-jerky. Today is our last video in the series of Credits Without Contact. So my co-star and I are going to be very sad. We're going to miss you all. We're going to miss our guests. We're going to miss this time that we've had with you. But hopefully we'll get to see you in person in not too distant of a future. Not going to spend a lot of time today opening this up. I want to get right to our guest, but just prior to getting to our guest, I would like to, for the last time, thank NACDL for putting these out there. I would like to thank Gerald Lippert and his staff for getting these together and getting these out to you all. And one last time, I'm your host, Laura Schile, Pocket Expert Forensic Consulting, and I am introducing you to the person that started this series with me and who will end this series with me. So give it up for Tiffany Roy, everybody. Hi, Tiffany.
Hi.
So I've gotten a little bit better, huh?
It's like, it's like a well-oiled machine now.
I'm thinking the next Ellen DeGeneres, huh?
There you go. I love it. I love it. The forensic Ellen DeGeneres. I love
That's
it.
right. With the child.
The child. I love it.
I didn't have him when we did our first. That's how long ago it's been.
When did he make his?
He got delivered and made his debut for my second guest. So the second show, you just missed the delivery of the child, who is soft and cute and wonderful in COVID times.
Yes, my son has a Mandalorian obsession. So if he saw that, he would want me to buy that.
This was pre-ordered before Christmas.
Yeah, I mean, it's popular. We watched the series, the full series, probably. I can't even count the number of times he's wanted to watch it. He has a favorite episode. He's 3.
Well, he's mentally my age then.
Yes, he's got very good taste. He's got high-end taste.
That's right. Well, yes, so this is a child. He came in. I didn't get to really play with him the first couple of days. He had to be sprayed down with hydrogen peroxide. Because I don't know where he comes from. And so I wanted to make sure that he was not bringing anything into the house.
No, I can understand that.
So Tiffany, you are the owner and the president of Forensic Aid, LLC.
That's right.
And you did our very first show, and we talked about the correlation between DNA transfer and COVID-19.
Yeah, transfer people.
And before we get started with your presentation, you've got a great presentation for us today. But just based on our last conversation, I want to talk to you just briefly about, I'm seeing it. I don't know if you're seeing it, but I'm seeing that it's getting more and more like forensics, insofar as the CDC, for example. I guess not like forensics, but there's a lot of correlation that is hard to explain in a forensic realm because you don't have a situation to compare it to, like DNA transfer. Now, I think people will really understand that DNA transfer, when you're talking about it and you're trying to explain it to somebody and you say, Well, remember when COVID-19 and we all had to wear masks and we all had to be socially distanced of 6 feet because COVID could transfer like that? That's how DNA transfers, and that's how sensitive, our testing is.
Right.
We can pick up that transfer. So another thing that came out recently was the CDC. The CDC did not follow its own protocols. And so the 26, they prepared test kits right away. This happened in January, I believe. They were preparing test kits for 26 different agencies. 24 of the 26 agencies, when they got the test kits, did the positive and negative controls and followed their protocols. And found that 24 of the 26 laboratories, those kits were contaminated. And they are saying that they're contaminated because CDC did not follow its own protocol. They had different teams in, they weren't changing lab coats, they weren't changing gloves, they didn't wear masks, and they had synthetic COVID in the laboratory that probably transferred into these kits because protocol wasn't being followed. So when the lawyers out there, you all, are saying, Laura, why do you need to get the protocols for the laboratory? Aren't they all the same? Well, no, they're not all the same. They should be, but they're not. In my opinion anyway. And you need to know what the protocol is to know that they have followed it. And I've had lawyers ask me, so what if they didn't follow their protocol? They say that it's up to the analyst's discretion whether to do things and follow it. Now, I think we can use these examples and say, CDC didn't, that gives us a tangible example of what can happen.
Yeah, contamination, is real. And just like transfer is real, so those things do happen. These are human people that are doing it. Not everybody does what they're supposed to do all the time. So that is all very important in helping us assess whether or not the court should be relying on the evidence. So I would think that this is a good all around. There's a lot of parallels.
There really are. And I think we might even hit on some more today, but I just, that was so recent that I wanted to bring that up with you because I think that I don't know if you get any questions about getting protocols or I've even had judges say, why do you need the protocols?
Yeah, there's certain places I have difficulty getting what I need in the state of New York. They do not have very friendly, I know they're trying to change their discovery laws and processes there, but yeah, it has been a challenge in some places, and other places, places like Washington, D.C. and Palm Beach County, they put their procedures online for everyone to see. So, and I think that's how it should be.
It should be very transparent. And again, the government laboratories, some of them, they feel that they're work product for the prosecution, and they're not work product for the prosecution.
Agreed.
And many different publications have pointed out that laboratories should never be seen as an arm of the prosecution or the police department. And I think that we've all seen trouble and scandals when that mentality is out there, thinking that they are.
It's out there.
It's out there. And so is the truth. And we're bringing it to you today.
Yes, we are.
So tell us what you have for us.
So today I prepared a presentation about weighting DNA evidence, all the different ways that scientists apply weight to a DNA match or inclusion, why that's important for a lawyer. And I know that statistics, it's like nobody wants to talk about statistics, and people, that's where I lose the lawyers. But we're going to talk about, the ways that I see that we used to do it. I consider there to be an old way and a new way. And there are still some people using the old way, and the old way is fine if you're using it correctly, but it's easy to mess it up. And, and we'll talk briefly about, some of the things that we can learn from past mistakes in paying attention to what labs are doing as they're implementing the new way. So I'm going to share my screen.
And you shouldn't be implementing the old way into the new way. A lot of times that's getting messed up, if you will.
Yeah, there's a lot of strange things that I'm seeing in my cases. So today I wanted to talk about real world examples of things that I have seen in the last few weeks and months, and things that I consistently see as problems in the area of forensic DNA interpretation and statistics, and why those are important. So,
and you and I talked quite a while on the phone about what both of us are seeing in 2020.
Yeah, and we're definitely going to touch on some of the things that we talked about. I'd like you to talk about what examples of things that you are seeing that are related to this topic. And I know that I said to you, I really think this is related, to what we've been discussing. And it's all the ways that I think forensic scientists are trying to make use of data that they shouldn't be trying to use. I understand it's frustrating to go through this whole process and test evidence and get results and be able to see things in the results, but not be able to report those because of the limitations of the procedures you have online at your lab, and the validations that you have in place. But, forensic scientists need to make sure that they're relying only on, data that they should be reporting and procedures that, apply to that type of data. So we'll talk a little bit more about that. Can you see? Okay, so can you
Absolutely.
see? Okay.
Yes, it looks great, and I love your logo.
Oh, that was new. I made that special for this presentation because I thought it looked pretty with the purple.
That is very nice. Thank you.
All the skills that I have. All right, so I'm trying to...
An artist as well as a forensic scientist.
Oh, yeah. One of the things that I didn't want to get too much into was the differences in the profiles and how we interpret DNA profiles. And there's a lot of good material on the internet, and I'm sure it's been the subject of many, many talks, that there are single source DNA profiles, and then there are partial profiles, and there are mixed profiles, and there are major profiles, and all different types of profiles. Well, what I want to discuss today is primarily that not all DNA profiles are created equal. There is a sliding scale. There's some DNA profiles that give us a lot of information, a lot of good, clear information, like a full single source blood stain. That's very informative to a forensic scientist. We know a lot about which information, what the genetic information pairs together. It gets less informative when DNA profiles get mixed together, and it's more complicated to interpret those. It's further complicated when we get partial mixed profiles or low-level mixed profiles, which we often call complex. But,
well, and let me jump in just real quick.
Yep.
It's not just less informative, but it's based on the same thing. It is, as a forensic scientist, what you're able to say varies dramatically.
Right. So,
and how you can say it.
And I talk a lot. So in my mind, what makes sense to me is like a physical description. And sometimes a witness can get a really good look at a suspect and give a lot of information to the police officer about the physical appearance of the person who may or may not have committed the crime, including things like height, weight, eye color, hair color, any distinctive tattoos, clothing they were wearing at the time. The more information you have, the more confidence you have in your conclusion when you find someone that matches up with that information. But if you don't have very specific information and you have non-specific information, which often happens with mixtures, it's a lot like this cartoon. So the eyewitness is drawing a stick figure and the investigator says, you're the only eyewitness, is this the best you can do? And sometimes that's what we're working with for physical, for the DNA information. It's like a stick figure for a physical description. It doesn't tell you a lot. Maybe it's consistent with a lot of people. Maybe it's, there's a lot of people who match up to, this 2 eyes and a mouth and little stick hands. It's just not super descriptive. And that's how I look at mixed profiles. They're just not super descriptive.
But I think one of the things that has to be, and we're going to do that today, and I'm probably pointing this out too early, is like Tiffany just said, they're not super descriptive. It may look like a stick figure in scientific terms, but what's actually going to be said on the stand? If the word match comes up, boy, howdy. That is wrong verbiage when you've got a profile looking like a stick figure.
Yep, there's a lot that goes into, the scientist might look at it and say, this is a stick figure profile. There's no information here, very little information here, but it was made to look very strong in the way that it was presented in court. And that can sometimes be from the scientists themselves, getting outside their lane, or it can be the way it's described by the opposing attorney, saying things about the profile. It could be asking the right questions and omitting information they find inconvenient about the profiles. There's a lot of ways this is done, but I didn't want to focus too much on that. I just want people to know that there's a lot of different types of DNA profiles, and sometimes we get a lot of information and sometimes we get very little information, and we have to have a way to convey that to the trier of fact. And the way that DNA experts do that is by attaching statistical weight. An expert has to be able to give some idea to the judge or the jury about which profiles are very strong evidence and which profiles are not so strong evidence that might associate with a particular defendant. So I put in this slide, there's some pretty good TED Talks. There's a good TED Talk by Dan Crane and Dr. Dan Crane at Wright State. He did a good TED Talk, TEDx talk, and then also Dr. Greg Kampikian's done one on a similar topic. But if you want to know more about DNA profile interpretation, those are good places to look and see the complexities involved in that. But the basis of the statistics, the reason we do it is because we're trying to express, what are the chances of someone coming up and just, we pick this guy out of nowhere and he happens to be included or matches the information. And sometimes the chances are high that can happen. And sometimes the chances are very, very small that we would pick a random, unrelated person. And so that's how traditionally we have expressed the weight. Anytime we make an association between a person of interest and a DNA profile, we say match or inclusion. If it's a match, usually it's 100% consistency between the evidence profile and the profile of the known individual. And inclusion is when we have mixed profiles. So the analyst doesn't know whose DNA is in that mixture. They are never going to know because they weren't there when the mixture was created at the crime scene. They can look at what is there, what data was developed, and then they can say who may be consistent with the data and who is inconsistent, who might be excluded. But traditionally we would say, what are the chances of randomly selecting, the person with the orange peaks just walking by on the road and he's an unlucky guy and he happens to be included. In the new way that we do statistics, we really say, what are the chances, we're weighing the difference between two hypotheses. So given the evidence, which scenario is more likely that, it's Mr. Orange Peaks or it's two completely unrelated people? What is more likely? And we've talked at some profiles. are different than others, and we get more information from some than others. So now is where I'm going to start talking about statistics, and this is where I lose the lawyers. I'm going to make it brief. I just want to talk about what I feel to be sort of the old way, the traditional way of attaching weight to DNA profiles here in the United States. And there are three main ways that this is done. I call these the binary calculations. Laura's really excited about this section. Yeah, so these are the binary calculations. We traditionally would use the random match probability for single source or major profiles, and that's reported as the chance of a randomly selected unrelated person matching the DNA profile obtained from the evidence. That uses a product rule. And
when lawyers, when lawyers are going through their case file, they'll see, they'll know what is being used by, it won't say random match probability, it will say RMP usually. Same with the combined probability. It will say CPI.
Or CPE, yep.
Or CPE.
But so these statistics are based on the product rule. That means we are looking at the frequency of the information at each location, and we multiply them over the whole profile. So it's what is the chances of a person having blue eyes, and what are the chances of somebody having brown hair, and what is the chances of someone having blue eyes and brown hair, and we do that over the entire profile, and the entire profile should become more and more rare with each piece of information. Combined probability, we call it CPI, CPE. It's also reported as the chance of a randomly selected unrelated person being included or cannot be excluded language. And then the other type of binary calculation that's described in what we call the NRC2, which is like the statistical Bible for DNA analysts, is the likelihood ratio. And the likelihood ratio is very popular in places like Australia and New Zealand and in Europe. And we didn't really use it here very often. There were not very many labs that used it. It's becoming more and more common because it's implemented through the new way. We use it in the new way. So we'll talk about it. But it still has the same limitations. There's two ways that the likelihood ratio is applied: the traditional way, the old way, which is a binary way, and then the new way, which is probabilistic. So we'll talk a little bit about that. For random match probabilities, the limitations and necessary assumptions that go along with that, usually we use these on single source or major profiles where we can resolve some of the genotypes and tell some information about what genotypes pair together, even if we can't get it down to a full single source profile. But it's based on knowing which allelic information.
I'm gonna jump in just real quick. Just for anybody who's viewing that hasn't had a DNA case yet, or hasn't had very many DNA cases, would you just be able to define single source and a mixture and a major and minor?
So single source profiles, just briefly, are profiles where we, the DNA analysts, can tell it came from one person. So it has, now we have, we're looking at something like 21 regular autosomal DNA locations in the new kits, and you get one or two peaks at each location, one or two what we call alleles, one from mom and one from dad. And so when we look at it, we can tell which peaks pair with what other peaks. So we can tell what the genotypes are. And that's very important in forensic DNA, knowing the allele combinations or the genotypes. Major profiles are when we can see that there are more than two peaks, but two peaks rise up above, much higher at each location than any other peaks. And that's indicative of a difference in DNA amount contribution. There's more DNA from one person than any other contributors that might be there, casual users, casual wearers, and that is another way we can tell what genotypes go together, because the peaks are so high, so it's almost treating it like a single source profile. In mixture profiles, we can't tell which peaks pair together. And so we have to take that into account when we're performing the calculations, that, there are different combinations that could go together. And that plays into our calculation. When you can't tell what genotype information might pair together, it makes the analysis a lot more complicated. So a great deal of what we do now, and a great deal of what the computer program does for us now in the new way, is trying to figure out the different combinations of the peaks.
And we also have, I'm just going to jump in, we also have, sometimes we get partial profiles. So we get what's called allelic dropout. And we don't have a full profile to work with. So we have partial profiles. And a partial mix sample is extremely difficult, many times is extremely difficult to what we say to deconvolute, to be able to interpret that partial mixed profile, especially if there are several contributors to that, that becomes very complicated and sometimes impossible.
That's a great word.
And it's okay. There's nothing wrong for anybody to say, there is no way for us to actually be able to tell who's in here. And so I'm gonna call it inconclusive, or you'll see INC, INC a lot of the times on the paperwork that you get in a case file. So those are all your basic starting points of the DNA, what we start to look at when we are going through a case file.
And really this comes into play. We're talking about the limitations, and certainly we talked about the random match, the RMP. Now we're going to talk about limitations of CPE and CPI. So the probabilities of inclusion and exclusion. When you have that uncertainty in your data, that's a huge problem for this calculation. The uncertainty, this calculation can't deal with uncertainty. You have to know all of your information is fully represented in that DNA profile. And so one of the limitations, one of the necessary assumptions, is that your data is complete, that you aren't missing any information. Because if you are missing something, then the person, a possible contributor's genotypes are not going to be represented, and they're not going to be included in the potential pool of people who might have been a contributor to that profile. And what happens is you get overweighted evidence. It seems a lot like a strong association or moderate associations when it's in fact very common, and we could find a lot of people, as contributors to that. So that's a necessary assumption, a huge assumption for the combined probability, that all the data has to be fully there and present and not partial in any way. We also have to assume that there are no related individuals. When we're calculating mixtures with the probabilities of inclusion or exclusion, we're reporting the chance of a randomly selected, unrelated person being included. And this is based on the idea that related people share more DNA and have a higher likelihood of inclusion if we already know one of their relatives is included. And then one of the other assumptions that we have to make is that all the people in the mixture are of the same ethnic background. And that's basically because we're using databases that are from different subpopulations. And so we'll report one number for one subpopulation, one number for a different subpopulation. Some labs report all three numbers. Some labs report the lowest number, the most conservative number. But that's a basic assumption that goes along with this kind of calculation. The likelihood ratio is very similar. The binary likelihood ratio is very similar to the combined probability. You have to believe that all of your information is fully represented. No non-specific, incomplete data. And the calculations are different. You have to change your calculations if you have related individuals. I think John Buckleton published a paper about what calculation modifications you have to make when you have relatives included in a likelihood ratio and for a DNA profile. And the same assumptions have to be made for ethnicity because we're using the same population frequencies and databases for those. So those are the methods for the old way, what I consider to be the old way, the traditional way. And the new way, the wave of the future, is star mix and true allele. So these are probabilistic genotyping programs. Some lawyers have heard of them. One of the first places to bring it online was the New York City Office of the Chief Medical Examiner. They designed their own probabilistic genotyping system called FST, the Forensic Statistical Tool. And there have been many New York cases that have dealt with FST. It's a big deal there. But now we have these commercially made programs that apply the likelihood ratio to DNA profiles, except that in different from the binary calculation, this computer uses algorithms to deconvolute the mixture and try to figure out what genotypes go together based on how the DNA profile looks. And it makes adjustments for uncertain data. So it accounts for information that might be missing. It accounts for information that could be dropping in from contamination, spurious contamination. So it can deal with uncertain data where the binary calculation cannot. It's definitely not perfect. It's still operated by a human person. It still has to be calibrated and validated properly. It still has to be checked by a human person to make sure things are making what they call intuitive sense. And nothing is ever going to be foolproof and flawless, but it's much better for consistency purposes than the old way. And we can talk about some of the things that have been going wrong with the old way and how those problems were discovered, what we know about them. And I'm going to show case examples that these problems persist today, even though we've been talking about them for something like 15 years now.
And it can be better if the operator knows what they're doing.
Right. If everyone's doing everything that they should be, and they've done, sufficient validations to show that the system works within certain defined parameters, that the analysts that are operating that software fully understand what it's doing and when it might be having problems, all of those things.
In New York, they had analysts who were going to the classes. This wasn't Star Mix, it was Trulio, I believe. They were going to the classes, taking the courses, and they did not know what was going on. A group of them. They were very confused by the information, and they never got that implemented. I believe they never implemented Trulio after several years of trying to do the validations with the analysts in the lab. But it's very important to realize that, number one, the forensic scientists are not statisticians, and I think every one of us will say that. If pushed on the stand with statistics, we were trained to say that. We're not statisticians, although all of us have had to take upper level statistic courses, graduate level statistic courses. But I think that it's very important to understand that if the analyst does not know how to operate this, then it fails.
Well, and they're not computer programmers either. These people,
Exactly.
is sort of like a black box to them. They have been told how this program works, and the math is so high level that they have been taught about it, and they know about it generally, but they didn't design the program. These are calculations that can't be done by a human person. So they're trusting this computer program to do the work. And some of them understand it only on a very, very basic level. And so we're going to talk about, but I think that is really the root of the things that we're going to discuss here today, is that forensic DNA analysts apply this in a vacuum and only to this one, and they use it in this one instance. They're not statisticians and they don't know the statistical theory, and they maybe didn't know that it even had these limitations, and so they were using it inappropriately, many of them, for many, many years, because they just didn't understand the statistical foundation for it. And what we have now is ripe for that as well. So even though I do feel that, you know, these new programs, the new way is the way forward, is the way to tighten this ship up, you know, I still don't see the kind of understanding that I would hope to see. And so I know that the kind of mistakes that we're going to discuss here today are absolutely possible, and we always have to remain vigilant. You know, it's not going to correct every possible mistake. So I pulled a great Government Accountability Office document, and I put the link in on this slide as a source because it talks about probabilistic genotyping software. It talks about what we call a PCAST report, President's Council on
Science and Technology.
President's Council, what's the A? Advisors.
Advisors.
Council of Advisors on Science and Technology. So
we'll get it.
Yep, I know it. Eventually I'll get it. And they reviewed this in 2015. They had some pretty serious concerns then about how it was going to be applied. And they talk about that. But one of the things I pulled from this is just to talk about, you know, the difference in how many people are moving forward and trying to adopt this new technology, and why some people are resisting the change and they don't want to do, you know, it's difficult to do something different, learn something different, and give over some of that control to a program that they will never understand the way the creators, you know, understand it. So about 100 laboratories, and this is a 1999 document, it was late 1999, I want to say, but they report about 100 laboratories in the United States using probabilistic genotyping software. And so everyone else, 3/4, there's about 400 crime labs. And there's some public labs, private labs in this country too, a handful. But if everybody has their own DNA lab, then, you know, about 3/4 of crime labs have not moved on to this technology yet, and are still doing things the old way. And even if they switched over recently, there are going to be cases that are working through the system that are still done the old way, you know, 5 or so years old. We're still seeing old way cases. We're seeing some new way cases, and but still a lot of old way cases. So why is the weight important? Why are these statistics important? Why are these scientists performing these calculations if they don't understand what they are doing? And it's because we have to give the trier of fact some estimation of whether it's a strong, you know, independent DNA profile or if it's a weak one. And that's not just required, you know, it's not just good practice because we want to make sure we're conveying the weight of the evidence, the true weight of the evidence to the trier. It's required as a part of DNA accreditation by ANSI. It's required, it's strongly suggested by the best practice guidelines of SWGDAM. ISFG, which is the International Society of Forensic Genetics, made recommendations that this should always be the case in 2006. And I do believe that the FBI quality assurance standards are going to address this in some way going forward. That, you know, a statistical weight is required when you're associating a person of interest with a DNA profile from an item of evidence. And every state has their own case law. In the state of Massachusetts, where I'm licensed to practice law, they have a case there that requires that there be a statistical weight attached. And here in Florida, where I live and I practice consulting, it's required as part of their state case law as well. So the courts recognize that that a DNA profile can be misinterpreted by a layperson if the expert doesn't tell them which end of the sliding scale that the evidence falls on. And the chances of being misinterpreted are high because DNA is very powerful evidence. People have a lot of faith and a lot of trust in DNA. And when someone says there's a DNA profile match, that means something to a juror. And the courts have recognized that. And so I urge everyone to look up what their state's case law says, clearly become familiar with it, because a lot of what I see, especially in post-conviction, is that analysts have done their due diligence and they do perform the calculations, but the testimony doesn't always reflect that. And that's a big problem for post-conviction cases. That's one big area where the evidence could be misconstrued by a juror, and DNA evidence is powerful. So if you have DNA evidence that's very important in your post-conviction cases, we're going to want to look at the testimonial record for sure to ensure that this stuff was admitted if it's required in your state. So what do labs do when they get DNA evidence that is uncertain, where we feel like there could be some information missing, or when they get DNA evidence where there could be related individuals, but they only have the old way methods online at their laboratory? What do they do when their blunt tool is unsuitable? The answer to this question is they will use that calculation sometimes inappropriately. And this could be, I don't think it's intentional. I just think that it's a result of forensic scientists not being statisticians, and maybe not everybody going out and reading everything that they should be reading, and getting the kind of training that they needed to get to use this kind of tool as a part of their everyday work.
And the protocols being, the protocols not stating exactly what should be done in this instance.
Yeah, and I think it rolls downhill. So the technical leadership in all the labs, sometimes they just don't know. And I know that that's like a terrifying thing to hear, that somebody that's, leading the pack and writing the procedures and approving all the procedures hasn't gotten the proper training and doesn't have the proper understanding. And there's a lot of reasons why that happens. So, if it's not in the procedure, there's a reason for that. It doesn't make it okay. It doesn't. And
by the time that we're seeing this, right, it's gone through at least one analyst. It's gone through a peer review by the tech leader, and then it's gone through an admin review.
And those are just the requirements of the FBI, and also accreditation is required by the FBI. So you're going to hear these analysts get up on the stand and say, oh, we have double and triple checks. And not just that, the accrediting body comes in, and analysts from other laboratories who are, volunteer assessors come in and they look at our procedures to make sure everything's okay. And they look at our validations to make sure everything's okay. And they look at a sample of the casework, and everything's okay. And we've been accredited. We are always accredited. And that's how the defense of that is going to go.
And that actually means, as you're realizing this, as you're watching this, that means nothing. Essentially.
No. The accrediting body is not, these labs are the clients of that accrediting body. I do not believe that they are in the business of making their clients look bad and revoking their accreditation. They are not looking oftentimes for the technical sufficiency of those procedures, more that they have a procedure in place so they can check the box. So you have a procedure for mixture interpretation, this box gets checked.
And one of the things, Tiffany, that I have told the lawyers that I work with, that accreditation, if ANSI comes in, if your protocol states that the analyst has to be standing on one foot while they're extracting, as long as the analyst is doing that, that box gets checked.
Whether it's good procedure or subpar procedure.
As long as the procedure is being followed.
And these assessors are other public and private crime laboratory analysts with varying levels of aptitude themselves. So the same way these problems happen at these actual labs, and then you have a problematic lab with problematic procedures, and then that person goes out and they're expected to check on other labs and catch these problems that they're not even catching themselves at their own labs.
That they don't even know are problems.
Right. So, so really accreditation for me is insufficient on a technical level. They just don't have enough skilled assessors. We don't have any national standards that are that these assessors have to meet. There's no aptitude test for them, and it's just not getting the job done. And so
We finally went to, I was pleased when we finally went to an ISO type accreditation. But the accreditation is not all that it is cracked up to be, and it is a start. I'll give it that it's a start, but we are such an infant field that as much as we're doing and as much as we're relying on the field, it's not good enough.
No, it's not nearly good enough. That's not enough oversight. It's not enough. These lawyers have more oversight than forensic scientists have. I mean, we don't have a body, a scientific. If I could take my concerns to A&AB and have them adjudicated in a way that I thought was fair and judicious and open and transparent, then I would do that. But I don't believe that that's what happens at A&AB. Those investigations are not published. They're not public. I'm not privy to what's been done, who's been executing these, who was spoken to whom. And there is no body. What my ideal oversight body would be the Texas Forensic Science Commission. I want every state to have a good and ethical and capable forensic science commission and some type of licensure or certification process for a singular forensic scientist in every single state. And if I could go to people that I thought were qualified to assess my complaints, a group of scientists, instead of taking some of these concerns into a courtroom, I would do it 9 times out of 10. I would win.
Absolutely. And you and I have talked. I'm gonna say that the Texas Science Commission, I think again that's a good start. I think that they are doing things that are costing them potentially I think they are costing criminal defense lawyers the ability to have good forensic analysts come in as qualified experts. And right. I think that their decisions at one point, it was great. I think that they have moved beyond what they need to be doing.
I don't know if it's the Forensic Science Commission that's legislated some of the rules. I know you and I talked about that. They're very stringent about who can offer forensic testimony in the courts in Texas. And that could be legislators. Those are people that are making the law. I'm not sure who writes the rules. And I think they may be different even in Texas from county to county about who's going to be allowed to give forensic testimony. And it could be statewide. But I do think that I guess have to do more research about what's going on there. But
and how it's written, I've taken it as people doing lab work.
Yeah, what lab work or affiliated with an accredited public crime laboratory, and that would be a problem. I mean,
yeah, if that actually is true. Now, I've taken it a different way, but many analysts aren't even touching Texas because of that. And so Texas has just lost out on a lot of good qualified experts. So what they're going to get are people that have worked at a state or county or city laboratory, no longer works there. They're the ones that can be the consultants, and that's it. That's not how I've read it, but so many people have that I've just got to put that out there that the Texas Commission may not be it's the right thought process. They may not be doing it correctly.
We just need I advocate that every state needs to have a commission. I want a commission I can bring my concerns to rather than trying to convince a judge. If I find an issue, it's so complicated that the members of your own crime lab don't fully understand it because there's a gap in the knowledge. How can I expect a lay judge to understand what I'm trying to explain to them?
And a commission that is transparent, a commission that has private consultants on the commission, as well as, so it's not just a government commission with right. government scientists on
right.
it. and prosecutors.
Yeah, we should see defense lawyers. We should see. I have seen that they do that in New York too. They have subcommittees. They have defense attorneys that sit on there. I'm not sure. I think they have some private consultants on the DNA subcommittee. But just in general, yeah, I just think that everything needs to be transparent, and there needs to be more. There just needs to be more oversight for sure.
And maybe one day OSACs will start taking that over.
I would love it.
I don't know, but it's not going to happen for quite some time, and until it does, all of you watching this have to know that forensic science, there are no set standards. That there are suggested, but the accreditation does not mean it is not as significant as what whoever's testifying is going to make it sound like it is, what the prosecutor is going to make it sound like it is. It's like a gold standard beyond reproach, and that's not what it is.
Yeah, a lot of people, I think Lynn Garcia, who works for the Texas Forensic Science Commission, gave some congressional testimony about the failings of accreditation and why accreditation is not a panacea. So if any defense attorneys want to check that out, I mean, it can open your eyes to what the true issues are and why accreditation is not catching some of these issues. So without any so this is where I'm going to start to get into the cases. So they use some of these calculations on data for which it is not suitable. And that doesn't necessarily mean that their conclusion is wrong. It just means that there has been some procedural problem, and the conclusion may be wrong. If they're reporting an inclusion and they have looked at the allelic information and they feel that person's represented in the profile and they think that they are included and they want to make an association, they can only do that if the profile is suitable for the calculation that they have online at their lab. And if they cannot perform a calculation because the calculation can't support that data, then they should not be making an inclusion. We should not be saying anything, that the data is not suitable for the tools they have in place. And that's the bottom line. So sometimes laboratories will handle this by saying something about, they won't say anything about the weight. I've seen some reports where they'll say Bob Jones is included as a possible contributor to this DNA profile, period. That sometimes, I find that happens in some of the older cases. We're talking about maybe early 2000s or late 90s, when we didn't have the same requirements as a forensic DNA community about statistics and about the weight in testimony and in our reports. It's less common now, but I believe in the Mix 13 study, which we're going to talk about today, when some laboratories would find that their calculations were not suitable, they would report the inclusion and then put in a disclaimer like the one that I've included here. It says a partial DNA profile from item, this is my really high level redacting skills, but partial DNA profile from item blah indicated the presence of a mixture with at least 2 profiles. So-and-so and so-and-so could not be excluded as potential contributors to this evidentiary mixture. And so-and-so and so-and-so are excluded as possible contributors to the mixture profile. Please contact this analyst for the name of a population geneticist able to testify to statistics. Whoever wrote this report can never testify to this in court, right? Because they have not reported a statistic. They cannot report this inclusion. They should not be reporting this inclusion. This is not okay under accreditation standards. And that little blip at the bottom there is not going to excuse them from my view of being absolved of the requirement that they include a statistical weight.
And yet hundreds of times this has been allowed to get out in testimony.
Right.
I've got these very same statements that just do not have the highlighted part still today.
And I have some cases where in the highlighted part there is a statistic that has been reported. And what happens is they get up on the stand and the analyst, I heard an analyst tell the lawyers in court that they have to answer the question that they've been asked. And this is just not true. And I don't know who trained them. And it's good practice.
Now, say that again.
They can only answer the questions that they've been asked.
Who said that?
Uh,
Not who, but an analyst?
A very high level analyst at a very large public laboratory here in Florida. And
said that to their analyst?
No, said that in sworn testimony on the stand, that they're bound. They can't say anything. I mean, they have to just answer the question they've been asked. If they've not been asked, then they can't say it on the stand. And that's not true, you know. As an expert,
that's why we're experts.
Yes, your duty as a lawyer, you know, you want to make sure that your expert's aware that, you know, these are how these things happen, these misconceptions. So if the prosecutor's eliciting this information, what did you find from item A? A partial DNA profile from item A indicated the presence of a mixture with at least 2 contributors, and Bob Jones cannot be excluded as a possible contributor. Even if there was a statistic in the report, sometimes they just don't offer it. And, you know, the testimony comes out, and if they don't say, and did you calculate a weight for that, the analyst might not circle back to that. And that's a problem. That's a big problem. It has to come in. It's required in their reports, and it's required in their testimony, because that testimony is the only evidence that the jury's going to consider, that they're going to hear. They're not going to likely get a copy of this report and see that statistical number. So what they say is so important. So another way that this can come out is a weight, the CPI, the CPE calculation, or the binary likelihood ratio has been applied to uncertain data where we don't think everything is fully there. There could be information missing. So they will sometimes try to make certain assumptions about the profile. They're required to state their assumptions. And Laura, this is something you and I talked about in our phone conversation, is that you sometimes will see a profile where the analyst will state, assuming 2 contributors.
Yep, have that right now.
Yep, and they're trying to break the profile apart into one major contributor and a minor contributor that looks uncertain. It might be dropping out. But if they say it's only from one person, what's left over can only be from one person, they might be able to salvage that data. But if it's a mixture,
I'm just going to go, what I have in that case is on several locations, I've got 5 and 6 alleles. Probably at 4 or 5 locations of the 21. I've got 5 and 6 alleles, and yet, which is indicative of a 3-person mixture. So in our technology, what we are taught to do is when we see something like that, we say at least 2 people. It's at least a 2-person mixture. I would have called it at least a 3-person mixture. However, in this case, in 2020, the analyst did statistics throughout those alleles and said, assuming this is a 2-person mixture.
Yeah, and there's a lot of ways this manifests. Their job is not to throw away data. Their job is to try to get usable data, and I understand that. And it's frustrating, especially if you can see things in the profile, and but there's a reason why we have these rules, and there are reasons why there are limitations. And if we don't follow the rules, then things could go wrong, and it could be misleading, and that's how we end up with wrongful conviction. So oftentimes I will see that you can tell. So in your cases, a red flag to know when the CPI or the CPE could have been used inappropriately is like what happened at the Washington, D.C. lab, where there was more than one calculation that was performed for different contributors, different potential contributors, for a single evidence profile. And that doesn't make any sense, because we are calculating these statistics based on only the evidence profile. We never consider the information from any potential suspects or persons of interest, and we would determine where we perform the calculations, where it's suitable, before we ever make a comparison. So if the statistical weight changes with the person being compared, then we know that some of their profile information is making its way into the interpretation at an inappropriate step.
Can you tell us a little bit about what happened in Washington, D.C.?
In the Washington, D.C. lab, there were some results that didn't make sense to a United States attorney. I believe it was Michael Ambrosino, and he has a close working relationship with Dr. Bruce Bedoli from the University of North Texas. And he contacted Dr. Bedoli for some clarification about some DNA in one of his cases that came from the DC lab. And Dr. Bedoli was concerned about what he saw. And that prompted them to request the United States attorney stopped sending samples to the lab, and they asked Dr. Bedoli and I think Dr. Fred Bieber to go in and perform an audit of the laboratory to see if they were doing things correctly, and they found that they were not. And one of the issues that they discovered, and they brought the accrediting body in after they had found these issues and showed the accrediting body what the problem was. And one of the issues was that there would be a single evidence item, single evidence DNA profile, but multiple CPIs for multiple people who are being compared. And that's indicative of what we call suspect-centric analysis. This is called suspect-centric CPI, and it's an improper application of that calculation, and it's an improper interpretation. It's extremely biased, and people can be wrongfully included in DNA profiles in limited, partial, mixed, complex DNA profiles if that process is allowed to continue. So that was one of the issues in Washington, D.C., and there were a few others that were noted. The report on the investigation there is public, and you can search for it on the internet and read what issues were found by Dr. Bedoli and his team, and also ANAB. You can read that accreditation audit report about what they found, and they found some additional things. But in general, this is what was wrong there. This is
I'm just going to jump in really quick.
Yep.
Suspect-centric analysis, the easiest way to look at it, I think, is that you, as a forensic scientist, get the data. You do your unknown or your evidentiary samples first. You run those, and then when you're looking at your evidentiary samples, you pick out, you make the determination what profile is there. The major, the minor, you write that down, and that is the profile or profiles that you call without knowing any other information. And what other information I'm talking about is what the known samples are, what the victim's profile is, or what the suspect's profile is. So you look at the evidentiary samples you don't have any of that in your head at the time. You just are looking at the evidentiary samples and making a call. Now, suspect-centric analysis is done backwards. The analysts are looking at the suspect's profile, and they'll have the suspect's profile here. They'll have the evidentiary profiles here, and they go and they say, where does the suspect fit into these this evidentiary profile?
I like the way that ITL Drawer, it's either Dr. Drawer or Dr. Peter Gill describes it as painting the target after you've shot the arrow. So you shoot the arrow, it hits the wall, and then you paint the target around that, and you're always going to hit a bullseye, right?
William Watson published a paper that talks about that very thing, as he's talking about cognitive bias. Yeah. And so that's a really good paper.
Yeah, and it can't be allowed, because you run a high risk of inculpating someone who maybe had nothing to do with the crime, and this is a very serious problem, and DNA is powerful. So this can sometimes happen. We sometimes see it manifest in that way. You can see multiple CPIs for a single evidence item, but for different people. And it can sometimes happen also when laboratories did not have a data metric to measure when information might be dropping out. We call it the stochastic threshold. So prior to the implementation of using a sort of data-driven way to assess when we might not have complete information, they would sometimes use the contribution of the defendant and assuming he was a contributor, and leave out any areas where he was inconsistent, and use the areas where he's fully represented, full donor representation. You can see how sometimes, there would be a problem with that. So when this happens a lot of times prior, in and around 2010, in that area, between 2010 to 2015, I see some cases that have suspect-centric DNA analysis because they did not have the stochastic threshold online. So this statement, this is from a case that I have currently, and it talks about a major mixture. And this is something that you and I talked about, Laura, that this is another way that laboratories will sometimes try to salvage data. They try to separate good, strong data where they feel like everything's fully represented from weak data that might be dropping out, and then they can still apply the CPI to the major contributors and disregard any minor stochastic or incomplete information. And that's a problem. It's a really big problem because a lot of laboratories are not performing the major cluster or major mixture analysis as they should be. There's a great paper on it. It was published by Fred Bieber, and he's the first author, but Dr. Butler, Dr. Badoli, Dr. Coble, Dr. Buckleton, all of those people were authors on that paper, and they talk about in one of the sections of that paper how to perform a conservative major cluster analysis. There's a math algorithm in there that you should be using to try to determine when you can safely call a major mixture and when it's not appropriate to use it. And many laboratories are not doing it like that. They have not properly validated the process for identifying a major mixture. In their validations, they don't even have a section for major mixtures to assess whether or not they can correctly pull them out. So this is a big problem that I'm seeing.
Again, one of the reasons that you need protocols, and that is just an epic fail.
Yeah, I'm really just kind of a bigger problem, but I think that actually went with the major, 0.3 was major cluster. And so those are when alleles, when you're dropping loci. I'm not a fan of dropping loci. I think you can wrongfully include people when you're dropping loci, especially if you're not doing that correctly, because all it takes is one allelic difference to exclude someone from a profile. And if you're going to drop that one locus and then someone's going to be wrongfully included, it's a real big problem. So, okay, so this is another case that I have presently where this combined probability of inclusion was used, and they had reason, I think, to believe from the beginning that the individuals involved in the case were related based on the this synopsis came from the sexual assault kit forms. It was taken by a sexual assault nurse examiner. It says patient states, I was at my boyfriend blank's house. We'll call him Jay. Jay's house. He said his dad was supposed to check on him and leave, but he stayed. He told me to go inside so he can talk to Jay. We were sitting outside. He came into the room where I was, put his hand over my mouth and stated blah, blah, blah. So it's pretty clear that this is the father of Jay, the boyfriend, and that has assaulted this victim. And as another section of the kit forms, it clearly says boyfriend's father is the assailant. And if you take a look at JF is the father and JB is the son. And these are their profiles as listed by this DNA analyst in the table. I've taken the liberty of highlighting all the allelic similarity between the two profiles. It is very, very clear that they are first order relatives. And so even if there was some ambiguity because they did not share the same last name, I think it was made very clear in the kit forms, in the police reports, and it's clear to me by looking at these DNA profiles that they're related. This analyst continued to report a mixture of DNA profiles from two individuals was obtained from the sperm fraction of the labia swabs JF, the father, and JB, the son, could not be excluded as possible contributors to this mixture. So now they've identified that there are potentially two related individuals that are included in this mixture and all the locations where they're included. And then they performed the combined probability of inclusion to report 1 in 2 quadrillion individuals randomly. What I love is the probability that a randomly selected unrelated individual, they still included the language. And this is written by someone who is the technical lead of this particular lab. And it's not that old. I have the date of this report in my I have a timeline in the end of this presentation that shows sort of the progression of these kind of issues and the discovery and the, where some of these other things are addressed. So I'll tell you where this case falls on the timeline and, how old it is, and how many years after these problems were discovered that this technical leader, violated this one major rule.
And everybody viewing this, that should scare you, I think. I mean, yeah, that is extremely scary.
Well, so here's the rub. In my report, I wrote to the defense attorney that this is flawed analysis because this mixture appears to be a mixture of the boyfriend and his client. And I reported that I think that this, they're related people. This is foundational. This person absolutely should have known they should not have been using this calculation for the relatedness reasons that I have already mentioned in this presentation. And that they should treat my report as soon as it's discovered to the prosecuting attorney and hopefully to the crime lab as a formal complaint to their quality manager, that they should on their own gumption go back through their cases and identify cases where this calculation has been used in this way inappropriately.
Now, can you take us back to that slide for a minute?
Yeah.
Okay. What should have been done in this case? What should this look like if it was properly handled?
It should say a mixture of DNA profiles from 2 individuals was obtained from the sperm fraction of the labia swabs, and it should say something like, it should be inconclusive at this laboratory. Our laboratory cannot perform any further analysis on this. You might want to request to send it out to, additional testing with a laboratory with different capabilities, or no inclusionary or exclusionary statements can be made regarding these 2 individuals because of their relation. That would have been fine.
So what you have here is where no inclusion statement should have been made.
Right.
You now have both of them not excluded.
Right. And you can't say
with a statistic.
Right. You cannot say cannot be excluded because you can't apply. They only have this tool at their laboratory to do these kind of calculations. So they're limited and this tool can't be applied. So they cannot make the inclusionary statement, but they can't exclude. What to do? They would have to put some language in this report to trigger and let people know that they're limited by their own capabilities. This is beyond our capability to interpret. And I think I have some language in here from Mix 13 where they tested laboratories, the National Institute of...
Yeah, I definitely think we should talk about Mix 13.
And I'm going to get to it, but Mix 13 sent out tests basically to laboratories, and one of the mixture profiles had information just like the information we've discussed here, where it contained mixture, I think, of brothers. And they wanted to see how laboratories would handle that. And some of the laboratories said no conclusions could be reported because of the relatedness. Some of the laboratories reported an inclusion, but had a statement similar to the first slide that we saw where it said, please contact, this laboratory for the name of a statistician, which I would not be okay with as a defense expert. And I would have, there would be motions as a result of that. But, it would require some additional analysis. You have to send it to someone who has the tools to interpret this kind of profile. And you can't just apply your blunt tool to this kind of data when it doesn't apply.
And those tools at this point would be a star mix or a true allele.
Yep, it would be.
Uh,
Or, they could send it to a laboratory with, I think the FBI has a statistician now on staff there. And some of the bigger, I think, private labs have statisticians that are there that can perform the kind of calculations that you would need to do for related individuals, but they need a different calculation. They just need
and instead of including these two individuals, that is just wrong on so many levels.
Yeah, binary likelihood ratio could have been applied here, but then the additional calculations that are described, I think it's either Balding or Buckleton that wrote the paper about how to deal with relatedness with a likelihood ratio. But there's like an extra calculations that you have to perform in order to have this be applicable to this type of situation. But
I want to say it was Balding, but I could be wrong.
The bottom line is just that these laboratories, this is someone in technical leadership position. This case was dated in 2017. So 4 years after Mix 13. And, after the problems that arrived in Washington, D.C., after a lot of I think, publication in the field of forensic DNA about the limitations of the CPI, that these people should have known. They absolutely should have known.
And prior to Mix 13, I just want to point out, prior to Mix 13, there was a Mix 5, and then they did the Mix 13. So just in case anybody's looking these up, you'll find a Mix 5 out there.
It's still on the NIST website. They did a big presentation. I attended the ABA prescription on forensic science at Fordham in 2014 when Mix 13 was presented by Michael Coble. So that was the first time I saw it. And yesterday, when I was preparing this presentation, I saw that presentation is still available on the Starbase website through NIST. But it just shows you that these scientists are not reading. They're not attending these talks. They are not thinking, they've not read Mix 13. They think it's critical of what they do, and it makes them look weak, and they have to answer questions about it from defense attorneys, and it really irks them. And it's, I had a scientist a couple of months back, I think, just brush it off as, well, they made those profiles in a lab, and they did it intentionally to trick us and to make it so hard.
It was too hard.
Right.
I hear that a lot. We never get stuff like this, so it was unfair. And the same group of people that are saying that about Mix 13 are the same group of people who there's pushback on PCAST. And the 2009 Strengthening Forensic: A Path Forward in America. But there should not be pushback. We should want to embrace that information and change it.
Well, these are good examples of why this industry cannot self-police. This is why we should not have forensic scientists auditing other forensic scientists and going back to their labs and being audited by, somebody they let slide a couple of months before. That just doesn't make any damn sense. So it's a compound issue, and we just can't self-police. And no one wants to be criticized. It's not fun to be criticized. I never liked being criticized. I still don't like being criticized. But
it's the only way we can improve.
And it's not about you. It's not about you as a scientist. It's not about me as a scientist. It's not about a laboratory. It's not about I understand this is their livelihood, but there are people. This is a justice system. We have to have faith in it. And there are people losing their liberty every single day. And that's what's the most important thing. We want to feel like this is built on a rock solid foundation, that what's being used to convict these people is good.
They could be losing their life over this evidence.
We kill people here in Florida,
And Oklahoma, Texas, Arizona. I think Arizona has a moratorium on it now. But yeah, they're not just losing their freedom, which is huge. And look at the protests we have going just with COVID-19 and the freedom that we feel that we're losing. This is nothing compared to what wrongfully convicted people are losing, or rightfully convicted people. they're losing their freedom, and some, based on evidence, are losing their life. And so we can't afford to have these mistakes, and we've got to be open for criticism.
Yeah. I'll never forget, seeing that presentation at that conference and understanding, what Dr. Coble was saying and the gravity of the, the continuing problems in the mixture interpretations, and that was countrywide. But I didn't really, until you get into consulting, until you see work product from many different labs, you don't realize that, not everyone's high quality. If you worked at a good lab and you feel like it was a good lab, you make the mistake of thinking that all other labs are good labs and that everybody's out doing their due diligence like you did at your lab and like your colleagues were doing. And that is not the case. And once you get out and you see a wide swath of work and you realize that, just like doctors, just like lawyers, that not all experts and not all analysts are created equal. Not all labs are created equal. And they're, everybody needs to be vigilant. So
I want to look at the laboratories, and I go in with a very positive outlook, hoping that they are a great lab and there's nothing, for me to do. And I truly try to take every lab that way, but it's not just that lab, it's each individual scientist and what are they doing and what are they getting away with. And every time I get a new case from a different analyst, I want to hope that they are really, really good, and really taking their responsibility as a forensic scientist as strongly as it should be taken. And unfortunately, even though I put on a positive attitude to go to every case, I find so often that something is wrong. It's a rare find, actually, where nothing is wrong with the case.
And I have cases. I had a case today where I conferenced with the lawyer, and the DNA is good. It's fine. It was processed.
And that's great that's great for us. I think I love it when I find that everything was done right.
Yep. And it does happen. I consult where I'm at. There's some good labs. I've seen work from good labs. I had, the pleasure of working at a good lab, but, not all labs are good labs. So.
Well, when I worked at Texas Department of Public Safety, the people that are still there, I think I can contest that was a great laboratory system. I was trained there. I think that I got quality training. I can't say that now because I haven't been there for so long, but you have to have an expert. If you've got DNA in the case, it doesn't have to be me. It doesn't have to be Tiffany. Get somebody to look at this.
And somebody with DNA experience. Somebody that's worked on the bench. I mean, I understand this.
Somebody good.
There's some really great academics, too, the people that have worked in the field that now moved into academia. But you wanted someone who has handled cases, someone with actual DNA interpretation experience. There's going to have to be people that are familiar with these tools that are coming out now, StarMix and TrueWill, and how those work and how those can benefit your case. So just make sure that you're picking someone, that was a real practitioner. I think that's very important.
I agree, and I think that you need to talk to your experts and see how what they've done in the past, and what experience they have. And you've got to, just because they've put a shingle outside of their door doesn't mean that they've ever been in a forensic laboratory or ever looked at protocols.
I just had a case where the technical leader of the laboratory, it's in the Midwest, and the technical leader of the lab had a PhD, but the only samples he had ever processed were parts of the validation. So So he'd never ever in his.
Oh my God. And
He's
that was a technical leader?
he's technically reviewing cases and he's giving expert opinions, but he had never processed an evidentiary item of evidence in that laboratory ever.
See, and you may not agree with what I'm about to say, but you know, I don't have a PhD. I know a lot of people will call me up and say, you know, doctor, and they'll mispronounce my name, but you know, Dr. Schile, you know, what do you, and I right away I say I'm not a doctor. And I do not feel that I am, and then I've had prosecutors continually call me doctor because every time I say I'm not a doctor, they like to hear that because they think that that diminishes me. When I got into forensic science, there were no even undergraduate courses that you could take as a forensic scientist. You know, I came in as a molecular biologist. I don't have a higher level degree, and yet I've got the experience, I've got the training. So I guess what I'm saying is just because there is an expert that's hung their shingle and they have a master's degree in forensics or a PhD in forensics, that does not necessarily make them better than an old fart that, you know, just has a BS or two.
It's hard. I don't know how to, there's no quick and dirty tips I can give lawyers for selecting a qualified forensic expert. There's no easy way to do it.
I think one of the ways is get on listservs, you know, and talk to other lawyers about who they've used and how that went.
I mean, sometimes that works, but sometimes, like, I know there's an expert that practices or has practiced here where I'm practicing now, who was widely recommended, and people really liked working with this person. He was diligent, very detail oriented. He had a medical degree. He had never practiced forensic science a day in his life. So he was getting, referrals, and I think, had the lion's share of the defense work. But I get his cases now on post-conviction, and there are things that should have been discovered that would have been discovered by a practitioner. So you just need to be diligent.
Well, and we know what should be there in discovery. We know what to ask for because we've prepared it in the past. You know, we've filled out the different forms for the thermocycler. We've filled out, you know, refrigeration log temperatures, right? We've done all of that in the laboratory, working in the laboratory. So we know what to ask for in discovery that a non-practitioner or a non-former practitioner would not necessarily know the key words to use.
Yeah.
I mean, I've had academics on the same case with me, and we were kind of doing the same thing for the same case, and yet they could never come up with even the right word for quants or electropherograms. You know, and that's pretty basic question for discovery. I mean, those are things that you definitely want in your discovery. So if you have an expert that doesn't even know the terminology, it's impossible for you as a lawyer to get that discovery.
Right. And to be fully prepared, you know, there's no way. And so I think the backbone of this is there's a lot of facets to why these problems continue to occur. Comes down to people not doing their due diligence, and everybody is not motivated by the desire and the thirst to know everything about what they're doing. You know, this is a job for a lot of people. They're working for the government. And I've heard it described by a lot of people as just being a kind of a cog in the wheel, and you do what you're told, and the technical leader makes all the big decisions, and you read your one paper a year so that you can, you know, check that off and maintain, you know, requirements of the FBI and accreditation. But they're not reading, and they're not taking classes, and they're not attending enough training because money is tight on the state level. These people aren't paid enough for what they do in general. And then they're not, these labs are not, the state governments are not investing in getting them the kind of training that they need. Technical leaders are not communicating the way that they should. I think there's a lot of reasons for that. Maybe it's somebody that's older and they have a PhD and they don't want to look weak to other people by asking questions and seeking clarification. Maybe they think they got it all figured out. Yeah? They've reached the zenith of everything that they can know, and they don't think that the field is changing fast enough, and they feel like they're on top of the world. There's a lot of reasons why there are these knowledge gaps and why these things exist. And just in general, I think forensic scientists are, just from a cognitive bias aspect, we're pretty self-assured people. We have to be pretty confident to do what we do and want to do it, and to take, such important information in our hands and manipulate it and try to draw data from it. And so just the idea that you could be wrong is sometimes foreign to.
You're saying that we have egos?
Yes. So I just think, all of these things come into play, and, these labs don't want to hear it from me. They really don't. I get it like a 55-year-old white guy with a PhD who's, the head of the lab. He's definitely not going to listen to me when I write my report and give it to the defense attorney. He's going to be like, who is this wahoo? But there's a lot of reasons why this is still happening. I'm still getting flawed cases, and it's still continuing to occur. So some of those.
And you and I talked about this just real quick. One of the issues that I think what happened is ASCLD decided, I think it was in 2000, in 99, 2000, maybe 2001, but I think it was 99, 2000. ASCLD said that if you were a technical leader, if you held that role as a technical leader, you had to have a master's degree or a PhD, and a PhD was preferred. Otherwise, you could not be a technical leader. Now, when they came out with that rule, they said that we will accept applications to allow, and I forgot what were they called, an exemption. We will look over the person that you're putting forth if they don't have a higher degree, and we will, after we vet them, and they wanted transcripts, they wanted reports, they wanted letters. I mean, it was a heavy vetting process. I know because I went through it, and I received an exemption. So I am an exempt ASCLD technical leader. I point that out because I think, and then from that point on, you couldn't get an exemption. So what happened is that you've got all these people, all these new people coming out of school with PhDs. They've never been on the bench, right? And they're technical leaders, and they don't really necessarily know what's going on. And I think that was a fail for ASCLD to do.
I mean, I don't know. I think it's good practice as a scientist, especially in a field that moves so quickly, is that you have to be comfortable learning. You have to never, ever stop. And that's really what we have to be expecting from all of the experts in the field, but especially, those people in technical leadership positions. And I understand that that's what they're trying to foster. It's just that to convey, and even if you've got a master's level and you have the master's level classes, like, no one can stop learning. That's why we have these CLE requirements, not CLE, but we have continuing education requirements. It's just not enough to just do the bare minimum. People need to stay on top of this stuff, and you take formal classes, take workshops, take online classes, all the training that you can consume. And you have to ask the experts when you're doing your pretrial interview or whatever. Ask them, how many papers have you read, and recognize that they probably haven't read like the expert you've hired has read. They don't have the same current knowledge that the expert that you've hired has. And again,
they're not taking it home and reading. I know at DPS, when that rule came about that we had to read so many papers and stuff, DPS didn't even want to buy the Journal of Forensic Science. They did, but they didn't. We had one copy in the lab amongst all of us to read and share. And I would go ahead and take it home at night and just bring it back. So I wasn't one of the ones keeping it from everybody else. But I didn't mind working at night. You know, I didn't mind working and not getting paid for it. But a lot of people that are working for the government, they don't want after at 5 o'clock, their time ends.
Right. And I think that's, that's pretty common. And they're working a lot. I mean, there's a lot of labs with a lot of cases, and I give them credit, but it takes more than that to really be fully educated in this field, especially with the speed with which things change. And this, the knowledge, our knowledge base changes all the time. Like what we were talking about transfer, the publications on transfer are coming fast and furious. If they're not reading that stuff, and they're still denying that transfer happens in case scenarios, then they're missing something. And so it's just making the time for being, these are the reasons why this all exists and why we're still seeing flawed cases. But I think it's going to continue even when we go to the new way. It's just partial understanding. They're just doing bare minimum. They've been told the bare minimum. They're cranking, they're hitting the button, and the cases are coming out, and that's going to happen. It's going to keep happening. So this slide, this is what I was talking about, the timeline of sort of the progression of the concerns with the CPI and major red flags that have gone up where laboratories have been misusing it or have demonstrated that we need better tools for consistency. So it really started in March of 2005 when the people at NIST, Dr. Coble, Dr. Butler, they sent out the MIX-05 study, contrived mixtures to laboratories, and they were waiting to get them back. Or I think maybe they were submitted back to NIST by March 5th, and then the data was analyzed. And this is a slide from a presentation that Dr. Coble presented on the International Symposium for Human Identification, which is held by the Promega company. And he presented this at this conference. One of his slides that he presented with this slide in it, basically said that there's a wide range of variation within laboratories and between laboratories across the country about what they're reporting for mixtures. And that's signaled a real problem back in 2005. I mean, that was 15 years ago. The FSIG issued their mixture interpretation guidelines in 2006. In 2009, the National Academy of Sciences report came out. It was really critical of a lot of the pattern matching fields, but not necessarily forensic DNA. And I don't think these problems had really been addressed by that committee in a way that, we sort of discovered at later dates, that there were really significant problems when it comes to pattern matching in forensic mixtures. And
I think that's why we see both prongs in PCAST.
Yeah. And I think that real reason was just mostly like, they called in the NAS report, DNA is the gold standard. And, it was based on science. It's based on empirical data and study. And we want that for all the other pattern matching disciplines. Well, yeah, that's great. But, we have information here that, there's just no consistency. Even if this field was founded on great principles, we have no standardization, and laboratories are doing things all differently. The data is not even the same.
It's not the gold standard.
Right.
Not yet.
I mean, I just think that I understand what they were trying to say in the NAS report, that, it was based on scientific study and empirical data, and came from a scientific process rather than just a necessary, a need to identify people like fingerprints started. But so 2009 was NAS. SWGDAM issued their mixture interpretation guidelines for the first time in 2010 and 2011. They really addressed the need for, consistency within the community about how we're going to interpret these mixtures. They started requiring the stochastic threshold. We really identified some problems, and we're trying to tighten up the ship. But In Mix 13, they discovered that, we're still all over the road. There are people that are still using the CPI on samples that are related. There are people that are making inclusions of people that are not even included in the contrived profile. They're making false inclusions. And it's because they're not thinking critically about the data. They're not trying to match the genotypes. They're looking only at the alleles that are present, and it's a really big problem. And, the Mix 13 was published, I think, in 2018. But the crime labs in Washington, D.C. So I saw this presentation. This slide is from a presentation that was from the ABA prescription in 2014. Washington, D.C. lab, the discovery of those issues was 2015. They discovered the same kind of issues statewide in Texas in 2015. And then they realized they needed to set a roadmap and clearly describe the rules for how this calculation should be applied when we're looking at data where there's uncertainty. And they published that 2016 CPI paper, Bieber et al. In 2016. And even still, even with all of this discussion in the field and all of these publications and all these published guidelines and all these presentations that have been given, the case I presented with the father and son mixture, that was dated in 2017. And I have another case where similar issue, it was two brothers. That one's dated in 2018.
One of the things that I think that we should point out, because I think that it everybody viewing this, I think that it kind of shows, again, the pushback of some of these reports. The Mix 13, everything was backed and ready in 2014. They were not going to publish that. They got a lot of push to publish it. So it actually came out in 18. You smile at that.
I smile because so this just became like super real for me. So I know that Greg Campikian at Boise State, who does their Innocence Project stuff there, has been a vocal critic of NIST, and the scientists who were involved wanted them to publish and, fought for a long time for them to publish. And I actually got a legal notification from the Office of the Freedom of Information Act at NIST over the weekend, and they wanted to notify me that they had a public information request, and it affected an email that I had sent Dr. John Butler in 2018, and a reporter at The Intercept had requested all communications between John Butler and any other person that deal with the topic of Mix 13. And so one of my emails I had sent him, I was asking him for a list of participating labs. There were 107 participating labs, and I wanted to know who they were. And I sent that email in 2018 to Dr. Butler, and they discovered it to this reporter at The Intercept. So there are people looking into, why that wasn't published, and I'm sure that that's going to be interesting to see, what they do.
Did you get the list of labs?
Yeah, he sent it to me, and he's, in the publication, it had not fully printed yet, which is why I couldn't get the list, but it's in an addendum in the actual published paper. They're coded though. You don't know which lab is which. So you won't know which labs are really doing screwy things, and which labs are performing okay and
Were you able to uncode it?
No.
Okay. Well, one of the things that also bothers me a little bit about this paper is that, first of all, it wasn't going to get published. And so finally it did get published in 2018. When it did get published, at the very, very top of it, it says that this is not intended to be used in court. It's not intended to be used as a critique. And I think it very much should be a critique. I think it very much tells us that there are issues that need to be looked at. I don't know why that was even put in there.
Well, this is only conjecture, but I believe that, you know, so they had been doing these interlab studies, and there have been a number. I think there are 4 or 5 interlaboratory studies that deal with mixtures that were sent out by NIST. And Mix-05, I think it had like 69 participants, laboratory participants or something, and they got the data back. And these are necessary diagnostic tools, right? We need to be able to diagnose problems like this. And so when Mix-13 came around, there were 107 participating labs. And I mean, we have already talked about that's a quarter of all the crime labs in the country by estimation. So that's a pretty good sampling size.
Yeah.
And they need those labs to participate. And if they're going to publish this, and then this kind of study is going to be used against the laboratories that are participating, they aren't going to want to participate going forward, because they don't want to be the noose that hangs them their own self, you know. And if they thought it was going to be used in that way, if they knew it was going to be published, then many of these labs would not have participated, and then we would not be able to diagnose these problems. And so NIST really, I think, is in a tough position in that they really want to be able to help and to know, you know, if people are doing things wrong, and they need the laboratory community to trust them and to want to take part in these things. But they also have an obligation when things have gone terribly awry to make that known in a very big way, because it's clear to me by the cases that I have that there are a great many scientists that have never and still don't fully understand what those problems were that they uncovered, why they were occurring, why that was problematic. They still don't know. So even though that was published 5 years after the fact, it still didn't stop my 2017 case or my 2018 case from having a CPI performed on a mixture with 2 brothers included in it.
Right. And it's still not, even the 2020 cases, it's happening.
Yeah.
And the thing is, what you really have to question is I think that your thought process is probably spot on, right? On the laboratory participating. But then you have to think, essentially, this was a CTS. And what CTS is for us, it's a company called Collaborative Testing Services, and they are one of a few companies that put out proficiency testing. And you've got to wonder, everybody that's working in a government laboratory is required to do a proficiency test every 180 days. What's the difference between this and a proficiency test?
Well, this is a mixture. And so I hear this all the time with analysts when they start talking about technical and administrative reviews and accreditation, and we're audited, and then I'm proficiency tested every 180 days, and I've never failed a proficiency test. Proficiency tests are single source profiles or simple mixtures of semen and blood, maybe.
Oftentimes the analysts work together.
And they don't test mixtures. They don't test complex mixtures. And that maybe was one of the primary motivators of NIST to check and see, you know, should we be testing laboratories for mixtures? Should we be trying to standardize this, you know? And I think the resounding result, and what we absolutely need to do, is absolutely implement, you know, proficiency testing for mixed samples, for complex mixtures. And we need to start standardizing these processes across the country, because it's still a mess.
And I guess why I say that is that, you know, all these people that get on the stand and want to talk about proficiency testing and everything, the same people that don't want to have NIST published or wouldn't participate again, that's crap. Either you're proficient in this or you're not. And either we have an entity that's going to provide proper proficiency testing, or all 400 laboratories are required to participate in a NIST study every, 2 or 3 years to see where we are and see what needs to be changed.
Agreed. I mean, the fear of failure and the fear of creating evidence that they are, could be doing things wrongfully is greater for some forensic scientists than the drive to ensure that your work is correct.
And how many labs got this right?
This mixture, so this was for the contrived mixture. This was one that, he really, he made it up and he made it difficult
It
intentionally.
was a hard mixture. I mean, it was.
And so for this one mixture, there were 5. For mixture 5 and for suspect C, who was a non-contributor, when they did the ground truth sample, they know they did not put this person's DNA in this mixture. So only 6 laboratories correctly excluded out of 107 labs. 3 labs were inconclusive for suspect C. 21 labs were inconclusive for all 3 suspects, and then 70 labs included him. So of 107 labs, we're talking about, approximately 70% of labs wrongfully included the defendant because they were not looking at the genotype information. They were going only on what alleles were present in the mixture. So they wrongfully included.
And if they had testified, if they had testified to that, not just the included ones, but quite possibly the inconclusive, depending on how it was testified to.
Yeah, I mean,
because I've seen analysts up on the stand that will essentially include an conclusive by what they're saying and by what the lawyer is bringing out from them.
Oh, so you couldn't exclude.
Exactly.
Yeah. So, I mean, it was really problematic. So, I mean, this is a big deal if 70% of labs are including someone who was not present. And I know that, they will say it was a contrived sample. They made it very difficult. Intentionally, they picked alleles that might overlap. But, it showed a very ugly reality.
But shouldn't that's what we're getting in casework? Shouldn't that represent, I mean, not all of our casework is a single source or a 2-person major minor component.
Yeah, I think we should be testing the worst case scenario. What's the worst case scenario? And, make it as hard as we could see it. I do agree. And I mean, like I said, I think that probabilistic genotyping is the answer for a lot of this, to take it out of the hands of the analyst and to do it in a mathematical way. That makes sense to me. But for me, looking at this now and I did this yesterday, I went through this and, there was a lot of head shaking going on. And when I got these cases, and I was going through them, the ones that are flawed, there's a lot of head shaking going on. Like, how could this be missed? But now we just ran headlong into this brand new computer program that we barely understand. And we expect in 15 years, we're going to start to discover that maybe, it struggles to handle mixtures when there's related people. Or, I want everyone to stop and think, if the field can resist this knowledge and continue to commit these errors, then why do we think that they're going to be correctly using this, this godsend computer software? And the only reason, the only thing that's going to make them do that is if we force standards on them. And then we also challenge them in courts and make sure we stay on top of them so that they know that they have to be on top of their game. I mean, that's the only way this is going to happen.
And I think challenging right now, what's happening in forensic science, the only way to have any accountability is for you as lawyers to challenge them in court.
Right.
Because otherwise they're going to continue to do and embrace new technology, easiest technology, without knowing what's going on.
Fully understand.
Yes. And so challenging them right now is our only avenue.
Yeah, and challenging them in an organized way, right?
Absolutely. Absolutely.
You may get a case that is, I see sometimes that, especially private attorneys, and there's limitations in representation in law. And public defenders are willing to do things and make challenges in the sake, of getting a ruling and trying to right this systemic wrong, where a private attorney might try to assess whether there's value in making those challenges and doing all that additional work and really bringing the lab to task. But you have to be working with the defense community. You should be on the listservs. You should know what experts are bad experts, and what labs are bad labs. And you may not win the first couple, but if you keep putting this in the faces of the judges and you keep bringing a parade of competent defense experts in the area, then eventually someone's going to take note. And
well, one of the speakers that I had on this series talked about motions. Jonathan Lawrence talked about filing motions and stepping up the whole motions game in litigation. And I think that's probably the best way, is to do all of this stuff outside the presence of the jury.
Yeah.
Because you think our audience gets bored and starts falling asleep, deer in the headlights as soon as we start talking about probabilistic genotyping, right? Not necessarily a very fun thing to talk about, needed, but not necessarily fun. Then you bring it up in front of 12 people that maybe don't even want to be there anyway. It's much better to do this pre-trial.
It is and it isn't. It really depends on the judge and the capacity of that judge. You have to preserve the record. It's important to file these motions and preserve the record, because you don't know what post-conviction judges you might, you don't know what's going to happen at trial. You don't know. There's a lot of unknowns. But absolutely a motion to exclude, Daubert or Fry, motions in limine to control the certain language. When you're seeing these kinds of things in the report, you're thinking, there's no way this person should be giving this conclusion without a statistic. Absolutely, preserve that with a motion.
And Tiffany, one of the things that you and I have recently talked about is a motion in limine for language that, say, for example, it's a partial profile or it's a YSTR, and they want to use the word match. Trying to identify a uniqueness, making it unique from any other individual in the population. That is a word that is no longer, that should no longer be used, should never have been used, but it is not a match when there's a partial profile.
Yeah, and I mean,
it's not unique if there's a partial profile. That needs to be kept out. Now, obviously, there's variables, and I'm just painting a huge, wide brush here.
Yeah, but I mean, and it takes a lot to preserve this and to argue these and to get in front of a judge and make these arguments. So you have to know what the status of the case law is in your state, especially as it like I said, Massachusetts has case law that's required, statistics are required. Florida has case law where statistics are required. You're going to have to include language in your motions from the guidelines of the accrediting body that requires it, and guidance bodies like SWGDAM and ISFG. It's helpful to have those. And there's lots of peer-reviewed publications. Like Dr. John Butler has, I want to say 3 really, really great textbooks that are very easy to read.
Yep.
Forensic scientists read them when they are training. We call them the Bible. There's one, I think it's Forensic DNA Typing, that second edition.
Yes.
Bible when I was training. And so you can find some of the stuff that's going to help you to support your motions in those textbooks. He talks about suspect-centric analysis. He talks about, the assumption of unrelated individuals within the mixture. And I already talked about these things are inextricably linked, the inclusion and the stat. And so when we start looking at post-conviction cases where I see a lot of errors, I see them in the testimony that the analyst never testified to the statistical weight. So it was free for the jury or the judge to think it was a 1 in a billion, 1 in a gajillion chance that, a random person would fit in, when really it was 1 in 4. And these numbers come with a plus or minus factor of 10.
Well, so, I think that one of the things, I'm going to jump back to motions for a minute. One of the things that your expert needs to be doing is helping you with these.
Oh yeah, they should know. Everyone needs to be following the case law in their state and across the country when it comes to big things like the Star Mix program. These experts, I follow any case, any challenge when there's going to be a new technology that's presented that's being challenged, especially if they're successful in excluding.
There's a website called Daubert Tracker that tracks some Daubert issues. It's kind of petered out. The person who was running it, I think, is deceased now, so it's not getting the updates like it used to. But your expert, like I travel all over the country, and I can't know all the case law in all the different jurisdictions that I'm in. But I do know I don't know all of them, but I do know a lot. I'm certainly very familiar with Daubert and Kumho and the trilogy with Joyner. Your expert should be helping you and even suggesting that a motion might be appropriate here. This is an appropriate case for this type of motion. Your expert should be helping you. And as like Jonathan said, when Jonathan Lawrence was on, have your expert available at these motion hearings to either testify, and if they don't testify, put them up as an offer of proof, as your offer of proof, to keep your record.
Yeah, for sure. And it's really easy, pre-trial to do that. The testimony is usually short. It's not like anyone's trying to beat anybody up on a lot of these issues. You just gotta make sure you preserve it, and at least go, try to get the hearing. In post-conviction, you're looking back, basically, I know I'm beating the dead horse, but if there's no statistic, that's going to be an issue. That's a motion, and that needs to be addressed. So things that I think would be good and helpful for defense attorneys to learn about these issues, these really serious issues, and things that I think forensic scientists should be paying attention to, but great resources to try to pull some stuff together for your motions. The ABA prescription is great. I know they have forensic college for defense attorneys up in New York City, but there are a lot of great TED Talks. The Starbase website on NIST has a lot of great resources that deal with forensic DNA. And the NIST Forensics website is really got a lot of OSAC stuff. It's got a lot of really helpful stuff for building these motions. If you feel that you have an affected case based on the language and some of the things that I had told you here today, you got to get somebody to look at it, somebody qualified, have somebody look at it. You want to work with an expert. One of the resources that I definitely want to point out to defense attorneys, and something that I use now in a lot of my cases, is working with the cybergenetics people. And they can go back to these old CPI cases. And if there's a lot of inconsistency with the defendant, I often have Trueallele, they'll run it for free. And I've had several cases where the analyst I've had inclusions, and I've had a lot of inconclusive cases where the Trueallele program is able to exclude a defendant. And there's a huge difference between inconclusive, I can't include or exclude, and the defendant being excluded. And so I don't recommend this just willy-nilly, because you're creating documents that could potentially be discovered and used against the defendant. So they need to be always, made aware of the kind of things, this kind of additional analysis. But and I always recommend you work with a qualified expert that can guide you when this is appropriate to do that kind of analysis. But this is something that I've been doing. And they offer that service for free, and they will tell you, if it's the attorney sending the information, you do what you will with it. But I've sent several cases, and they've been extremely helpful in helping where the analyst falls short, where a human person can't do it or refuses to do it, to make exclusions from DNA profiles that would have otherwise inculpated a person. So just a general summary, this field, we talked about it. It's not as gold as we make it. There's some tarnish on the gold, and human people are performing this analysis, and human people can make mistakes. and they continue to make mistakes for a lot of different reasons. And there are a lot of different reasons we've discussed about why these mistakes continue to happen and why there's still a knowledge gap. But errors can and do happen, and a qualified expert should review DNA records before trial, in advance of trial, with plenty of time so that you can make motions if something is up. And they can also assist if DNA was a strong pillar in a post-conviction case. If if DNA played a role in a conviction, and it was done 2010 prior, even now I'm still finding problems. You should have somebody look at that and make sure that all of the
if we're finding problems right now in current trials, in current litigation, that there's potential problems on appeal and post-conviction levels.
Yeah, and it's vital to the more this information gets out, the more courts are going to be aware of it, the more appellate judges are going to be aware of it. And so you just have to make sure you're preserving the record. You've got to preserve these issues. You just don't know what's going to happen for the defendants and if they should be convicted. These are the kind of things that will help the post-conviction attorneys hopefully down the road. So that's all I have today. I know that it went on a long time, and
no, Tiffany, thank you so much.
No problem. I'm passionate about this topic. I love this field. I find it to be interesting. It helps a lot of people. There's a lot of great things that can be learned from it, but it's not perfect. And I would like to see things change and things get better. And I'm gonna do my part to make sure I tell everyone that.
Well, and God bless you for doing that. I feel the exact same way. I've been doing it for over 25 years now, and I just it almost makes me sick to my stomach when I've got this report or I see testimony that is erroneous or misleading. It hurts because that's my field, right? And I don't want to see that in my field.
I mean, I'm happy at times, that I'm able to do it, that I'm able to see it, that I'm able to address it. But also it does it does take a toll, and we're just not where I thought we would be as a field and where I think we should be. And I know I've talked to some other really prominent defense experts, and they've said this, something similar, that they just can't believe what they see on a regular basis. So we need to do better.
Yeah, I mean, just even down to protocols, right? We don't have to reinvent. We just need to standardize. And there are some labs that have it right. That doesn't necessarily mean the analysts are always doing it right, but there's some labs that have it right. And we've got to take that, and hopefully at some point, all the labs will be doing it correctly.
That's the hope.
Yes. And I've been hoping for that for a long, long time. And I know that you have the same passion that I do, and it's always enjoyable to speak with you. And
I appreciate you having me on. Thank you so much, Laura, for giving me this opportunity to do this.
Oh, absolutely. I thank Tiffany. This is the last show that we'll have. I hope that everybody is doing the best they can during this pandemic. But I want to thank all the speakers that I've had on Credits Without Contact. NACDL, big thank you for just putting this out and making it available to all of our great champions. And Gerald Lippert, who is in charge of the CLEs. I big shout out to Gerald, and thanks for letting me do this. And all of the speakers have come on and put together these presentations on their own time, on their own dime, just to make sure that you all have hopefully top quality information, because that's what it's about. Let's get the facts out there. Let's challenge what's out there, and you know, where it looks like at this point we're the ones that are trying to make it better, Tiffany. It's through us and through our lawyers, which are all of our viewers, that are going to make forensics a real science, a real field. And it's through their challenges and their hard work that we're going to see that happen, I think.
Agreed.
So I'd like to thank everybody. Stay safe, continue to wash your hands, and maybe next time you won't be seeing this eye candy on a video, but you'll be seeing me in person somewhere. I hope that I can meet all of you at some point. And thanks so much, Tiffany. Thank you all for tuning in, and you guys have a terrific day and life.